It's 10 o'clock, so good morning and welcome to Hill Dickinson's Spring Real Estate Update. And thankfully, looking out the window, it is finally starting to feel a bit more like spring this week. Once again, over 500 of you have signed up to attend this event, so thank you all for joining us this morning. And since we last all met back in the autumn, it's been a very exciting time for the Hill Dickinson real estate team. You will recall that in summer of 2022, we established a real estate team in Leeds, led by Richard Outhwaite. And having outgrown our old Leeds office at the start of this year, we moved into fantastic new offices in Leeds at 11 Wellington Place. This year has also seen us open a brand new office in Birmingham. And in the last few weeks, that office has welcomed a real estate team led by Ben Aitchison and a real estate litigation team led by Tim Rayner. So we now have real estate lawyers in London, Liverpool, Manchester, Leeds, Birmingham, plus a healthcare real estate team based in Newcastle. Turning to today's seminar, I'm very excited that we can offer three fantastic speakers for you. Kicking us off in a minute will be Ruth Cochrane. Ruth joined us last year, very experienced real estate lawyer, and is making her debut on our seminar program today. And Ruth will be looking at some of the real estate aspects of the Levelling Up and Regeneration Act. Ruth will be followed by Rachel Allen, who many of you will know. Rachel has become a regular fixture on our seminar program, talking often about green issues. And this morning, Rachel will be looking at the latest iteration of the Green Lease Toolkit, published by the Better Buildings Partnership. And then Helen Evans, who's a partner in our real estate litigation team, will look at the options available to a landowner when they are faced with trespassers on their land. We'll then have time for some questions at the end, so please submit your questions as they occur to you in the box, and I'll ask as many questions as we have time for at the end before I bring the event to a close no later than 11:30. Now, you can download a copy of today's presentation slides if you'd like them from the related content box on the screen. And if you want to revisit the event at any time, you'll be able to use the same joining link you've used today to access a recording of the event. We'll also send you all a follow-up email with a link to the slides and that recording. Now, when you leave the event today, you'll be prompted to complete a very short survey, and we'll be hugely grateful if you would please just take a minute or two to give us your honest feedback on today's event. So anyway, without further ado, I now hand you over to Ruth. You're having a slight technical difficulty with Ruth. Just bear with us and we'll try to get Ruth online. If not, we'll change our order and we'll let Rachel go first. Cool. In that case, then I'm going to sort of just fast forward through and hand you over to Rachel. Thank you very much.
Morning, and thank you for joining us today. I'm going to talk about the updated Green Lease Toolkit launched in February of this year by the Better Buildings Partnership, or the BBP for short. For those of you who don't know, the BBP is a UK industry body of leading property owners working together to improve the sustainability of commercial buildings. It aims to provide practical tools to support the delivery of better buildings for investors, owners and occupiers, and the communities in which they operate. It believes that engagement with occupiers should be at the heart of owners' sustainability strategies. The text on this slide shows the stated aims of the BBP. For the purposes of this seminar, we all need to understand what a green lease is. The BBP say it is a lease document with additional clauses providing for the management and improvement of the environment and, optionally, the social performance of a building by both the owner and the occupiers. But it's important to remember that there's no standard form of green lease. Green lease clauses are often roughly divided into light green, medium green, and dark green. The shades of green reflect the wide range of different types of green lease provisions that might be used, whether they're legally binding or not, and the extent of the burden that they place upon the parties. Most new leases now contain some green clauses, which can help landlords and occupiers alike comply with the current and future regulatory targets. These are statutory targets set out in things like the EPC regulations and the MEES regulations. Green clauses can also help parties gather data to meet ESG disclosure requirements and certification requirements. Green clauses can help to enhance reputation in the market, and that can sometimes provide a competitive advantage. The Green Lease Toolkit was first published over 15 years ago. It was updated in 2013, but since then there's been a change in the market and in the regulatory landscape behind it. The updated toolkit builds on what was contained in the 2013 toolkit, and it introduces new model clauses which shift the toolkit from being one that was mainly designed to protect the existing levels of the environmental performance of let buildings to one that encourages legal commitments to be entered into to improve aspects of the environmental performance of buildings. The updated toolkit is the result of over 18 months of collaboration between investors, owners, and occupiers and their representatives, including agents and lawyers. The aim was to create a balanced tool to help landlords and tenants work together to improve the environmental performance of commercial property. Central to the new toolkit is the notion of improving environmental performance. The term environmental performance has been redefined in the updated toolkit to extend its application beyond energy and water use, waste generation, and greenhouse gas emissions, which we're, I assume, all familiar with. And it now includes biodiversity and resilience. The updated toolkit aims to foster collaboration at all stages of the leasing process and to encourage positive and open dialogue between the parties involved. This slide gives a flavour of what's involved in the updated toolkit. There's a lot there. Guidance about what a green lease is, drafting for green lease clauses, and the example clauses are free to use and they're really helpful. A version of the widely used model commercial lease precedents has been used as the base document for the drafting, so that should make the clauses easy to slot into most modern leases. Perhaps even more helpful for investors, owners, and occupiers and their agents is that each clause is prefaced by a statement of intent. The statement of intent is an overview of what the clause is designed to achieve. For the majority of clauses, there's a choice of light, medium, or dark green drafting. For some clauses, however, including data sharing and metering, there's only one option, and that's to reflect how fundamental the BBP view the adaptation of that drafting to operating a green lease. Green Lease Essentials. This is a checklist which outlines 10 key areas which the BBP would expect to be covered as a minimum for a lease to be considered a green lease. Whilst the BBP is not a standard-setting body, the purpose of the essentials is to encourage the industry to move beyond the most basic green lease provisions, increase ambition and collaboration between owners and occupiers, and for the essentials to become an accepted industry norm for the greenness of leases. Heads of terms. BBP rightly state, in my view, that the heads of terms stage of a negotiation is a key moment to communicate the importance and the ambition of green provisions to be included in the lease. The toolkit includes guidance and template wording for use in heads of terms. This is high-level, upfront wording that landlords and tenants can agree to set the direction for further negotiations on the main terms of the lease. The updated toolkit also includes advice on owner and occupier engagement. This is to help foster positive relationships and enable an alignment on sustainability goals. The toolkit also includes case studies of green leases in practice, as well as links to other useful resources. Now, we can't cover everything in this session, so This morning, we're going to have a look at the options for heads of terms that are included in the toolkit, as I think that that's probably relevant to everybody attending this session. As I mentioned, the BBP recommend referring to green lease terms in the heads of terms to underline their importance and to ensure that parties and their advisors address their minds to green issues at an early stage. It can help speed up the legal drafting and minimise the risk of green lease clauses simply being struck out by solicitors. The BBP suggests that there are three options for addressing green issues and heads of terms. Which is going to be most appropriate will depend on the nature of the real estate asset, the circumstances of the negotiation, and how much detail parties want to cover at heads of terms. The BBP suggests that where clear plans already exist to improve environmental performance of premises or the building or the estate where they're situate, or where a tenant has specific environmental performance requirements, then the parties may be able to agree more bespoke and possibly more ambitious terms based on what those plans or requirements are. Option 1, offered by the BBP, is set out on this slide, and it's something that us solicitors and you clients and agents will see regularly in heads of terms. The relevance of this option really depends on if the landlord has standard green clauses for the building or the estate. The ease with which the parties can reach agreement in principle will depend on what those clauses say, their appropriateness for the particular property and its proposed use, and where the parties are in their respective ESG journeys. Option 2 provides a more detailed template. It directs that the lease will include green clauses addressing the items set out on this slide. The cooperation heading refers to the inclusion of an obligation on the parties to cooperate on and to have a forum for discussion about the environmental performance of the building and the premises, and optionally the social impact of the premises and the building or estate. A lot of this is about setting tone. Considering social impact's a fairly new thing, and it's an acknowledgement that buildings can have a significant impact on the lives of those who interact with them, and that the real estate sector is well placed to create positive social impact. Data sharing is one of the key things for BBP and the industry at large. As some of you may be aware, the City of London Law Society Certificate of Title has recently been updated to include a statement that the landlord and the tenant share data relating to environmental performance. And as such, I expect that this will become a market standard position. The BBP tell us that it is exploring how data sharing between owners and occupiers can be effectively facilitated, and it hopes to be able to provide additional guidance to landlords, tenants, and managing agents in relation to this issue. Metering is really important to enable efficient environmental data collection, and things like smart building technology are also relevant here. Landlord's works rights. These are about extending the landlord's rights to do works to improve environmental performance of premises, buildings or estates. The BBP think that, given the urgent need to reduce greenhouse gas emissions over this decade, it's important for landlords to have the option, but not an obligation, to carry out such works unilaterally to improve environmental performance during the term of a lease. The guidance also provides advice to landlords about how such clauses are likely to affect the landlord's position under the MEES regulations. In particular, how clauses of this nature could result in the landlord losing a right to claim exemptions. A landlord's request for such rights is likely to be contentious in my view. Occupiers will be concerned about potential interruption to their business operation at the premises, and both parties are going to be concerned about the costs of carrying out such work. Now, one area that the toolkit does not address with its draft clauses is the issue of the cost of any works by a landlord to improve environmental performance of the premises. The MCL suite of documents provide that the landlord can carry out such works to the premises only if the tenant in its absolute discretion consents to them. And if the tenant consents, then MCL provide that the tenant pays for the costs. The toolkit promotes a slightly different principle here, being that the tenant should only contribute to the cost of those improvements to the extent that they result in savings for the tenant. And it cites examples of drafting from the US and Australia, which seek to implement that principle. Sustainable use isn't about works. It's about behavioural matters which can affect the environmental performance of premises and, where applicable, buildings or estates. This heading includes things like not operating real estate assets in ways that are wasteful in terms of the amount of water and electricity consumed. Prevention of works refers to the prevention of works by either party that would have an adverse impact on the environmental performance of the premises or the building or the estate, and the protection of environmental ratings. I think that this may be okay for things like office premises, but I think negotiation can be more tricky for some industrial and food type uses. Waste is about minimising waste to landfill and maximising recycling of waste. Circular economy is about the landlord and the tenant carrying out any works to the property in a way and with materials that minimise the use of resources and which avoid waste and greenhouse gas emissions. Renewable energy. This is about the promotion and procurement of renewable energy. Service charge is about taking environmental performance into account in the service charge. The BBP encourages the parties to act reasonably to agree the proportions that the landlord and tenant will contribute to capital expenditure to improve environmental performance of the real estate asset. However, it suggests that the parties might also consider including a fixed contribution within the lease at heads of term stage, or drafting a payback calculation, whereby the tenant will contribute towards the capital expenditure, but only if the changes result in energy savings which pay back over the contractual term of the lease. If the works do result in cost savings by way of reduced energy or other utility costs for the tenant, then the BBP is of the view that it is reasonable for the tenant to contribute to capital costs to the extent that it will benefit from the cost savings. The BBP suggests that how this is achieved should be a matter for agreement between the parties. It acknowledges that service charges are always site-specific, and that services a landlord will provide and a tenant will pay for need to be carefully considered on a case-by-case basis. Option 3. In my view, option 3 will require the most focus from a negotiation between the parties on green issues at the outset. Hopefully that will mean that the lease draft and the negotiation will be less contentious and more efficient. It's just front load in the process. We've looked at a lot of the issues that are covered by the various headings shown on this slide in our overview of option 2. The additional broad issues that should be covered at heads of term stage if the parties are adopting option 3 are shown in green on this slide. The EPC's heading relates to provisions governing when and the process by which an EPC is obtained by a tenant, giving the landlord control over this so as to ensure consistent and high quality EPCs are commissioned. I think this is unlikely to be a contentious point in most lease negotiations. Reinstatement is about provisions requiring the landlord to serve notice if it does not require alterations to be reinstated at the end or sooner determination of the lease, having regard to any adverse impact on environmental performance, except for waste, in requiring reinstatement. The BBP suggests that where reinstatement is required, the tenant should be obliged to minimise the amount of waste that is sent to landfill and to maximise the amount that is recycled. There are optional requirements for tenants to share waste data or to incorporate reference to landlords' waste policies or a recycling target or an agreement on a compliance with a recycling plan. That will all be situational specifics. Standards. Standards are about preventing the tenant from using the premises in a way that adversely affects any environmental rating for the premises or the building. The BBP suggests that the environmental ratings referenced in these provisions should be those that have actually been obtained or which the landlord is under a contractual obligation to obtain in respect of the building. Again, this might cause issues for certain types of user, and the BBP have also suggested a sweeper provision to allow the landlord to pursue future environmental ratings in respect of an asset during the term, and it includes drafting to allow for the environmental rating to be rebased during the term. I think that this could prove to be quite contentious in many lease negotiations. So what's next? It's important to remember that the BBP is not a regulatory body, it's not a standard setting body, and nobody is obliged to use the Green Lease Toolkit. However, as with the previous toolkit, I think it's likely over time that the BBP's updated Green Lease Toolkit will influence the market and the types of green clauses that are commonly seen in new leases as we all move further along our green journeys. As we become more familiar with the new toolkit, I think we'll increasingly see some heads of terms including some or all of the headings that the BPP have suggested in their 3 options. And perhaps we might even see statements of intent in there. Maybe we will see heads of terms include directions to adopt a BBP light, medium or dark green position in respect of certain headings, as we now sometimes see in heads of terms directions to use MCL drafting. This type of approach at heads of term stage would really focus the parties' attention on the issues at that early stage, and it would, as I said before, it would increase the level of negotiation in heads of terms, but reduce the amount of time taken for lease negotiation. So it's about front-loading lease negotiation processes. One thing that I would say is that we should remember that a green lease doesn't automatically result in a more environmentally efficient or sustainable building. Commitments required from both parties to work in partnership to optimise the energy efficiency of buildings and to address environmental and social impacts. Collaboration really between the parties is the critical ingredient to the success of a green lease. Finally, I think it's important to also consider existing leases. Earlier this year, the UK Green Building Council published its report on the case for retrofitting office buildings, and that found that optimisation alone, on average, resulted in a 26% reduction in the operational energy use intensity of offices. And landlords are increasingly seeking green provisions on lease renewals. Some tenants will resist the inclusion of new green provisions in renewal leases, particularly if they have the benefit of the 1954 Act, and that's because they usually make the lease more onerous for the tenant. Where the parties have, in a handful of instances, asked the court to decide if such new green provisions should be included in a renewal lease, the courts largely seemed inclined to side with the tenant. The government's expected to consider the extent to which the Landlord and Tenant Act 1954 should provide a mechanism for introducing green provisions in statutory lease renewals. And following that review, the tables may be turned. What I'd say on that is, don't hold your breath. I think we've been promised reviews of the 1954 Act on more than one occasion, and there's been very little change there. So, in conclusion, the original version of the Green Lease Toolkit was produced in 2008, and since then it's been one of the BBP's most widely used tools, and it's helped to inform thinking on how leases can be drafted to support owners and occupiers' sustainability ambitions. I think that the updated toolkit is really good, and it's going to be very useful to everybody in the real estate industry as we all work to our increasingly ambitious ESG targets, which, as you know, are being driven by the regulatory background as well as the change in market norms. I am now going to hand you over to my colleague Helen, who's going to talk to you about trespassers. Thanks for your time.
Thank you, Rachel. In fact, I think we have Ruth reconnected now. Hoping, sorry, yes. So I'm hoping we will go back to Ruth for Levelling Up and Regeneration Act. Over to you, Ruth.
Hello, everybody. So hopefully you can all see and hear me now. It is slightly unnerving sitting on this side of the fence because I can't actually see you. So I've no idea if you're riveted or if you're wandering around the kitchen making a brew. It's a bit like being a radio presenter. Maybe I should have done a jingle. Unfortunately for you all, I'm going to refrain from singing and we'll save that special treat for another day. So let's get this show on the road. So I'm here today to talk to you about the Levelling Up and Regeneration Act, which is said to speed up the planning system, hold developers to account, cut bureaucracy and engage more councils to put in place plans to enable the building of new homes. Now, it all sounds fantastic stuff, but bearing in mind the Act was passed by Parliament and became law on the 26th of October last year, many of the measures are not set out in detail, so further regulations are required before they take effect. So people should keep an eye on the progress of the implementing legislation in the coming months, which will add some flesh to the bones of the Act. We don't know when the secondary legislation is going to be forthcoming, and with the prospect of a general election at some point this year, it's a case of watch this space. I might well be sat here in 12 months' time telling you to ignore everything that I'm about to say. So let's look at some of the headline provisions of the Act, including standardisation of enforcement for planning permission, high street rental auctions and contractual controls over land. So firstly, let's examine some of the key provisions, starting with standardisation of enforcement for planning permission. And I'm going to point out at this point, I'm not a planning lawyer. So it's intended as a general overview only, so please direct any difficult technical questions at Bill. So apparently, the Planning Inspectorate is committed to improving service delivery time for all types of appeals, including planning inquiries, the process for which can obviously take a long time and hold up developments. They've set themselves ambitious goals for dealing with appeals within certain timeframes, so even planning inquiries will be held within 26 weeks. He's hoping that the Land Registry follow suit in dealing with their applications, but that's another topic entirely for a different day. So let's look at some of the key changes that the Act introduces around planning enforcement. The regulations around planning enforcement were made on the 2nd of April. These are the regulations that bring the enforcement packages that are set up in the Levelling Up and Regeneration Act into force, and subject to transitional provisions, they come into force tomorrow on the 25th of April. So one of the biggies is the introduction of new time limits for taking enforcement action. So the four-year time limit for bringing enforcement action against building or engineering operations and changes of use for a single dwelling house will be removed. So this applies in England only. It'll still be 4 years in Wales. So a single 10-year tariff will apply to all breaches of planning control. So the 10-year limit for bringing enforcement action will apply where alleged operational development was substantially completed on or after the 25th of April 2024, or where the date of the alleged change of use to a single dwelling house was on or after the 25th of April 2024. So it's quite a big deal, and no doubt inquiries are going to be raised as part of transactional DD going forwards around this matter. And for anyone out there who is intended to submit an application for a certificate of lawfulness for the existing use or development based on the 4-year period, the position's changing as of tomorrow, so you do need to be aware of this. Let's look next at enforcement warning notices. So local planning authorities can issue enforcement warning notices inviting regularisation applications when it appears that a development's taken place in breach of planning control. The issuing of an enforcement warning notice will constitute enforcement action, and as such is therefore relevant to then the second bite provisions, which will remain in force. So the Act introduces changes to the restrictions on appeals against enforcement notices. So if a Ground A application has been made for retrospective planning permission, the circumstances in which an appeal against an enforcement notice can be brought on Ground A are limited under the Act. This will apply in circumstances where applications for planning permissions are already made to regularise the breach. These amendments do not apply to appeals against enforcement notices which were issued and have not been withdrawn before tomorrow, 25th of April. The Act also introduces powers around undue delays in planning appeals. So the Planning Inspectorate will have the power to dismiss appeals against enforcement notices and certificates of lawfulness on grounds of undue delay by the person lodging the appeal. If at any time before or during the determination of the appeal gets an enforcement notice or certificate of lawfulness appeal, it appears that the person responsible for the delay, the person making the appeal is responsible for the delay, the planning inspectorate may do one of two things. Firstly, they can give the person notice that the appeal will be dismissed unless they take steps specified to expedite the appeal within a specified time frame. Or secondly, if the person fails to take those steps within the specified time period, the appeal can be dismissed. So these changes do not apply to enforcement appeals against a refusal to grant a certificate of lawfulness that were made before tomorrow. The power is in addition to existing powers where the planning inspectorate may dismiss an appeal if the person making the appeal fails to submit supporting evidence within this prescribed time limit. And before exercising the powers, the appeal parties will be given a final warning notice. And I think the idea generally is that it will only ever be used in a small minority of cases, but this remains to be seen. I appreciate that I'm firing loads of dates at you here, but on the basis that most of them are tomorrow, it should be easy enough to remember. Let's look now at high street rental auctions. So bonus points for anyone who can name the town pictured on the slides, if my accent's not already given that away. I'm sure that plenty of you will have had experience of town centre redevelopment schemes in recent years, whether it's in your hometown or a scheme that you've been involved in. In a former life, I've dealt with a couple for local authorities in the Northwest, so I must admit I did get quite excited when I heard about this. So the government ran a consultation on the proposals, which closed in July last year. Part 10 of the Act gives local authorities power to put vacant high street properties into rental auctions, the aim being to reinvigorate high streets and town centres. Further details are waited through secondary legislation, so we don't know the finer details yet, but we do know what was suggested as part of the consultation process. I guess what we also don't know is the appetite of local authorities to utilise the process or how well it'll be received. I mean, I can think of numerous examples where local authorities are already heavily invested in town centre regeneration schemes, and I'd hope that this process is just another tool within the toolkit to facilitate successful regeneration schemes. At this point, I'll don my geography teacher jacket, which is tweed with leather patches on the elbows, in case you're wondering. Anyway, I digress. The point is, local authorities are empowered to designate an area as a high street or a town centre where there's a concentration of high street uses there. In the case of a town centre, the area must be a built environment principally characterised by a network of streets. The local authority is required to maintain a public list of these designations, and the designations will constitute a local land charge, which would show up on a local search. So high street uses are not just retail uses. It's quite a wide definition, which is similar to commercial, business and service use within use class E. It includes shops, offices, community halls, compatible small industry or manufacturing, leisure, entertainment and food and drink. It does exclude warehousing and residential uses which are outside the scope. So the local authority could determine that the premises is suitable for high street use, where it would benefit the local economy, society or the environment, which again is really wide. The property needs to have been unoccupied for more than one of the previous 2 years. Now, when they talk about unoccupied, it seems that it requires substantial occupation. Sorry, when we talk about whether it's occupied or not, it needs to be substantial occupation, which is sustained and involves people being at the premises. And also, interestingly, the sale of the property without occupation resuming straight away will not start the clock running again. So how does the process work? So the local authority would serve an intention notice on the landlord, which would prevent the landlord from agreeing a tenancy or licence without the consent of the landlord. The local authority. The local authority has to give consent if the landlord finds a tenant who will take a lease or a tenancy within the 10 weeks of the notice with a use that's going to attract people to use the premises. If the landlord doesn't find a tenant within that window of opportunity, the local authority may put the property under a final letting notice. The notice must be served in time for it to take effect before the initial notice period expires. We don't know what take effect means until the secondary legislation provides further clarification around this. And whilst a final letting notice is in place, the landlord will be restricted from what it can do with the property, including things like carrying out work, as well as letting the property without the local authority's consent. The final notice period is 14 weeks and can be subject to extension in some circumstances, such as the landlord appealing the final letting notice. Now, there's only certain grounds on which the landlord can appeal the final notice. For example, if they wanted to occupy the premises themselves, they wanted to redevelop it, or if they dispute that the property is suitable for high street use. But bearing in mind the wide definition of high street use, they might be hard pushed to argue it on that grounds. Failing successful appeal, the local authority can put the property into an auction process, and the property can be let under a lease, which is excluded from security of tenure provisions, for a term of at least 1 year and up to 5 years. The consent of any superior landlord or mortgagee is deemed to be given. Again, there's further detail needed around the process, and there's obviously questions about how the procedure is going to work. But if we look at what the consultation paper said, they said that there should be no reserve price or reserve rent. The local authority got the option of outsourcing this process, and the auction will be on a sealed bids basis, with the landlord having sole discretion over choosing the successful bidder. And the consultation also envisaged that standard documents would be used to speed up the process, which should obviously be, a good thing. The consultation considered how the costs would be spread, and it would be proposed that the landlord would be obliged at their own cost to bring the premises up to a minimum standard so that they're safe, stable and secure, ready to be let. There was some discussion around whether MEES would apply for the duration of the agreed term, because obviously there's substantial cost implications if a landlord would be required to bring the property up to standard. So it does remain to be seen if the provisions will breathe new life into bustling town centres and transform them into vibrant places where people want to shop, live, work and relax. But I mean, I don't think anybody could really argue with the sentiment. The powers are permissive, so there's actually no obligation on local authorities to use them. They're discretionary, and the consultation that stated that the use of the power is not intended to apply in the case of properties where landlords are actively seeking to fill them. It's rather where vacancy rates are a significant issue and landlord cooperation is low. Now let's look at part 11 of the Act, which looks to provide greater transparency on contractual control agreements. So things like options, preemptions, land promotion agreements, conditional contracts relating to registered land in England and Wales. Now, most of what I'm about to say was detailed fantastically in an article that Rachel, that you've recently heard from, wrote earlier this year. And I don't wish to take credit for her great work because she explained it much more eloquently than me, but I'm going to give it a go. So there was a consultation which launched in January and concluded just over a month ago on the 20th of March, but we've not heard anything further since. The consultation sought views on the government's plans to provide a more transparent picture of the controls on land through creation of a freely accessible data set. So whilst contractual control agreements like conditional contracts, preemptions, options are protected on registered titles, they're not recorded in an easily accessible way, because obviously us lawyers need to keep some magic around this stuff. The idea is that the data set would allow prop tech companies to create applications and systems which would improve efficiency and transparency in site identification and assessment by local planning authorities and developers, better help demonstrate the path of development in a particular area. So the regulations are expected to commence in April 2026 and affect new and existing agreements entered into from April 2021. The government does not propose to publish the actual agreements, but just extract certain information contained in them. So things like the date and the type of the agreement, the contracting parties, the term of the agreement, the property it relates to, and also the SRA details of the solicitors involved. The responsibility for submitting the information would sit with the solicitors involved, but the main issue here is that the retrospective effect. So obviously for some investors and developers with large portfolios, the scale of the review that would be required to comply with this would be burdensome, especially bearing in mind that there'd be criminal sanctions for failure to comply. So if secondary legislation is introduced to bring this into force following the consultation, if that's likely to impact your business, get in touch with us and we can help you through the process. Now I am going to hand over to my colleague Helen Evans, who's going to talk to you about trespassers.
Thank you, Ruth. Good morning, everybody. I can't see you. Hopefully you can see and hear me. I'm going to be talking this morning about trespassers, and in particular what landowners can do to protect land and property from unwanted trespass. I'm talking about this topic for a couple of reasons. Firstly, there's been some important case law handed down by the Supreme Court concerning remedies for trespass, and it is, I'm afraid, becoming more and more prevalent, with land and property owners often left to sort out issues such as trespass and unwanted occupation for themselves. So the purpose of my talk will be to talk about the different types of trespass and to explore what landowners can do if faced with these problems. I'm conscious I only have, I think, about 20 minutes. So I'm going to be focusing on trespass onto private land as opposed to trespass or aggravated trespass onto public land, such as the public highway. And whilst I will be referring to some key cases and some legislation, you'll be really pleased to hear that this talk is not heavy on technical law, because in this particular area of law, practical knowledge and experience is key and essential. And thankfully, we have a significant amount of that in our team. So as we know, there are, of course, different types of trespassers. There are the environmental and political activists who occupy land and property in the name of direct action, which is usually designed to disrupt or interfere with certain business activities and operations. And then, of course, we have squatters and travellers who occupy land and property to live. Both types of trespass can be disruptive and very damaging for property owners. But before we jump into potential remedies for landowners, I just thought it'd be helpful to look at what trespass actually is. And very simply, a trespass is when someone enters someone's land or property without permission. It's as simple as that. It's a very simple cause of action, and all it really requires is for someone to prove that an individual is on or possibly over or under somebody else's land without consent. And the claimant is usually the landowner or somebody with a legal interest in the land, such as a lease, who has a better right to occupy the land than the person trespassing. So it is a very, very simple cause of action. So turning to remedies, I'm firstly going to look at remedies in the case of environmental political protest and larger groups of travellers. And in the case of, say, an environmental or political protest, where activists have taken possession of a field or a site that perhaps is earmarked for future development into an oil and gas site, or perhaps a site to be used in medical testing, and there is a clear and targeted campaign against that industry or business, the main objectives of the landowner will be to stop the action, remove the trespassers, and to stop it happening again. And in that situation, a landowner will usually apply for not just a possession order, but also an injunction. A possession order is usually the preferred option because of its superior enforcement mechanism. Possession orders obtained from the High Court can be enforced by High Court enforcement officers who have the power to remove people and vehicles from land. Those officers are well trained, very experienced, and will physically come onto the land and secure possession for the landowner, albeit such action is quite expensive, but they do have the powers to do that. In addition, an injunction will also be sought to stop the trespassers returning, and the courts have powers to grant injunctions, as we'll see shortly, where it appears just and convenient to do so. Similar remedies can be sought in respect of travellers, and in fact, many of the leading cases in this area of law involve local authorities and travellers, where local authorities have sought to move travelling groups on from particular sites within an area and to prevent them returning. I could spend quite a lot of time running through the evolution of that particular case law. I don't have the time for that this morning, but the one case I do want to focus on is, it's listed up there on the slide. It's the case of Wolverhampton City Council and London Gypsies and Travellers. This is a Supreme Court decision that was handed down in November of last year, so it is relatively new law. To quickly give some context, those engaged in direct action in the course of protest, i.e. those doing the trespassing, rarely willingly reveal their names. So they are often referred to in legal proceedings as persons unknown. Now, Part 55 of the civil procedure rules being the court's rules, which govern possession claims, does permit claims to be issued against persons unknown. However, the position in relation to injunction applications has been less clear. And so this decision, the Wolverhampton City Council decision, has finally provided some clarity about remedies that can be sought against persons unknown. Now, usually an injunction to deter trespassers will be granted on an interim basis. This is usually because travellers have gone onto the land, they are causing some disruption, the landowner needs to get rid of them as quickly as possible to move them on, and they seek an emergency relief. And so an interim injunction is usually granted, and that order granted by the court will be reconsidered later prior to being made final. However, one very key procedural question that the courts have grappled with for the past few years is whether it's actually possible to grant a final injunction against persons unknown. In 2020, Judge Nicklin, sitting as a judge in the Court of Appeal in a case referred to as the Canada Goose case, because it involved a protest action against retailers of animal fur, said that interim injunctions could be granted against persons unknown, but that final injunctions could only be granted against parties and individuals who had been identified and who had also been given the opportunity to contest the application. If anyone in the category of persons unknown at the time the final order was made could be identified, they would be identified and they would be bound by a final injunction order. If the individuals could not be identified, then a final injunction against persons unknown effectively bound no one and was useless. So that decision of Judge Nicklin brought to a halt many of the protester injunction applications that had been going since 2018, particularly those relating to claimants in the oil and gas industry who were facing trespass and issues with protesters. So this case of Wolverhampton concerned a number of co-joined cases involving travellers and local authorities. Injunctions were sought by local authorities seeking to prevent unlawful encampments. And since members of the travelling groups could not be identified, they were referred to as persons unknown in those proceedings. So the question for the court to consider was whether the court had the power to grant an injunction that binds persons who are not identifiable at the time the order is granted. And this is the big question that we'd been asking the courts to consider for the past few years. And effectively, those individuals who could not be identified at the time the order was granted, and who have not at that point infringed any rights, but would do so in the future, those individuals were described as newcomers. The Supreme Court's decision in Wolverhampton was that, yes, newcomers can be bound by final injunctions. And so effectively a new type of injunction has been born, and it's been referred to as the newcomer injunction. In their judgment, the Supreme Court judges held that a newcomer injunction has the following distinguishing features. Apologies for the word on the slide, but I thought it was important to put all of the points on there. Newcomer injunctions are made against people who are truly unknowable at the time the grant of the order is made. So these are orders to stop people who are unknown trespassing. They are always made on a without notice basis, obviously, because those against who the order is being sought have not been given any advance notice of the application. In the context of travellers, they are made in cases where the persons restrained are unlikely to have any right or liberty to do that which is prohibited by the order, save perhaps some human rights, which are to be considered proportionately and balanced. The conduct restrained is typically either a plain trespass or potentially a breach of planning control, or maybe even both. And accordingly, these injunctions are generally made where there is unlikely to be any real dispute to be resolved about the claimant's entitlement. So these proceedings are generally more considered to be an enforcement of undisputed rights than a form of dispute resolution. So there's no complex legal question to be determined by the court here. It is simply a case of a claimant is an owner of land or has a legal interest in land, and it is seeking to stop people trespassing and interfering with its interest. The newcomers would be unlikely to engage with the proceedings as active defendants for obvious reasons. We don't know who they are, so they won't be served. And actually, experience tells us that even if we do manage to serve them, and over the years we've adopted some very creative ways of serving protesters via social media, Facebook and the likes, even if they are forewarned about the proceedings, they just don't want to become involved in proceedings because they don't want to expose themselves to any adverse costs orders. The mischief against which the newcomer injunction is aimed, although a serious invasion of a claimant's rights, is usually short-term and liable to be repeated on the same site or potentially on a nearby site. And so, therefore, a possession order is not an effective remedy for that situation, where there is a strong suspicion that the trespassers will simply return. For that reason, the injunction is sought for a medium to long term, rather than to provide short-term emergency relief. And so therefore its purpose really is to provide protection of rights and interests, better protection than any other sanction available, i.e. a possession order, as we've mentioned. So taking into account the features, the court has also, in this judgment, which is quite long, issued some guidance on how they are to be applied in practice. So there must be a compelling justification for the order sought. That applies to all injunction applications. And also it must be just and convenient to make the order. The order must also have built into it certain procedural protections for the rights of those who may be caught by it. For example, they can make an application to set aside or vary the terms of the order. And all disclosure duties which attach to these sorts of applications, which is, for example, making sure that interested people have been given attendance notes of without notice hearings, for example, that all must be complied with as well. So the newcomer injunction is very helpful. The Wolverhampton case has provided some much needed clarity on this particular area of law. And it should be a useful tool for local authorities and landowners looking to deal with the problem of persistent trespass. So now I'm going to turn to possession actions. And some of you may have seen this headline in the written press over the past couple of weeks. Squatters have apparently broken into the York and Albany pub in London, which is one of Gordon Ramsay's establishments. And according to the press articles, the trespassers have barricaded themselves in using some of his kitchen equipment and have apparently refused to leave unless ordered to do so by the court. The articles have further reported that the police have apparently refused to provide assistance. One can only imagine Gordon's reaction to all of this. And I understand that this unit was empty, and Gordon's team were in the process of negotiating a surrender with the landlord. And it's often a case that a property is most at risk when in the process of a handover or assignment, and unlawful occupation during that process is something that happens not just to celebrity chefs, but also to some of our clients as well. And we've recently had to assist clients deal with this problem. So imagine the following scenario. Client is a landlord who is in the process of agreeing a new letting of a property recently vacated. However, whilst dealing with that process and potentially also trying to deal with fit outs or delapse, contractors turn up one day to find that the property has been unlawfully occupied by trespassers. What can the client do? Well, if the trespassers are spotted early, a common law notice can be served, and it must be served within 24 hours of the trespassers' arrival. And the notice must be asking them to leave. If they refuse to leave, enforcement officers can remove them using only reasonable force. However, this is obviously risky because what constitutes reasonable force? It will remain a criminal offence to use excessive force or any violence. And so depending on the trespasser's behaviour, a common law notice might be ineffective. The police now have more powers to remove trespassers. In addition to the powers conferred on the police by Section 61 of the Criminal Justice and Public Order Act, the police could remove trespassers in certain instances, such as where damage was being caused, trespassers were using abusive language or being abusive, and where there were more than 6 vehicles involved. And the introduction of the Police Crime Sentencing and Courts Act in 2022 sought to extend those police powers by making trespass in some instances a criminal offence. It was thought that, in theory, the introduction of this legislation would make it easier for landowners to deal effectively with trespassers. So, pursuant to the PCSCA, an offence will be committed if a person over the age of 18 resides or intends to reside on land in or with a vehicle without the landowner's consent and fails to leave or fails to remove their property or re-enters as soon as they've left after having been asked to do so, and has caused damage or is likely to cause significant damage. As to the meaning of significant, we're not entirely sure, and that will be assessed on a case-by-case basis, but would include things such as damage to land, property, the immediate environment, disruption to the use of the land or to the supply of utilities to that land, or it could even be distress via offensive conduct, such as the use of threatening language, abusive behaviour. However, in reality, the police will rarely exercise these powers. And if true as reported in the written press about Gordon Ramsay's situation, it doesn't surprise me to hear that the police refuse to attend. That leaves landowners with the court system and issuing a claim for possession via the Part 55 of the Civil Procedure Rules. And this is the course of action that most landowners are forced to take. However, as some of you may be aware, the court system is not what it was pre-COVID. In the pre-COVID world, we'd be often able to obtain a possession order with a fair wind within, say, 72 hours of being instructed. Now, I would say that 2 to 3 weeks is more normal, and obviously a lot of damage can be caused by trespassers in 14 days. And trespassers know their legal rights, and they will know the process that a landlord has to go down in order to obtain a possession order. The county court system is, and these are not my words, these are words reported by the Times recently in an article, going to hell in a handcart. This article followed a survey conducted by the Property Litigation Association, of which I, along with the rest of my team, are members. And many of us actually did complete that survey. The current administrative delays seen in the London County Courts in particular is eye-watering. I think I read an article recently which suggested that the administrative delay in the London courts was around 17 to 18 weeks. To try and deal with that backlog, they have introduced a centralized call center, which actually in practice for us makes things far worse, because you can't actually contact the court to request updates or to chase hearing dates or to chase orders and so on. Some courts are better. I'm going to give shout outs to Cardiff, Liverpool, Birmingham, amongst a few others. But many courts now in this post-COVID world, are seeing significant administrative delays. And I'm afraid that is causing frustration, not just for us, but also for clients as well. But it is something to bear in mind. So what else can landowners do? Well, deterrent is better than cure, especially if that cure involves either relying on the police or the county courts. And so our advice to clients currently is to make sure that adequate security measures are in place. Trespassers, in my experience, are not particularly bothered about being seen on CCTV. They will cause damage if necessary to gain entry. And the best form of defence is a robust physical barrier, concrete bollards, for example, to stop them entering in the first place. And I know sometimes clients might think that's disproportionate, but actually the cost of having to pursue a possession action and also to enforce via High Court enforcement officers can run into the, easily 10,000 plus. So it is something to strongly consider if a landlord is very, very keen to keep its property safe. I give credit to my colleague Ralph Bullivant for the picture, which I stole from his Instagram feed, and it was posted during a recent holiday of his. A sign like that might put me off climbing over that gate, but I'm in no way advocating that landowners should be poisoning their land or putting any other harmful substances on the land to deter trespassers. I'm pretty sure that could open up a whole other can of legal issues for landowners, so please don't do that. And I've obviously put my disclaimer on the slides just in case later you look at that picture and think that's our advice. It's not, but I just thought it was a good example of a potential deterrent. So I believe we'll be taking questions, and I'm happy to answer the easy ones here this morning, and we'll happily follow up with any harder ones by email later if necessary. But thank you very much for listening to us this morning.
Thank you, Helen. In fact, a massive thank you to all our speakers this morning. I'd now welcome our speakers back to form our Q&A panel. Don't forget, still time to download the slides from today's seminar from the later content box if you haven't yet done so. Right, thanks to everyone who has submitted questions. We have a number of questions already submitted, and if you have any more, please put them through now. It's always nice when we have questions for each of our speakers. So I'm going to sort of go through, rotate round our speakers. So the first question asked this morning is a question for Rachel on the Green Leases Toolkit. The question is, this is a really important topic, but how do we ensure costs are allocated fairly between landlord and tenant? Is there any industry guidance other than a matter for negotiation? Now, look at the time the question was raised. I think that was before you started talking about the cost recovery mechanisms under the MCL regime and what's recommended under BPP. But is there anything else you would add there, Rachel, in terms of industry guidance, or is it just still a matter for negotiation on a transaction by transaction basis?
It really is a matter for negotiation. So just to recap, the BBP promotes a position whereby if the occupier is going to benefit from cost savings as a result of the capital expenditure to improve environmental performance, then to the extent that they will benefit during the term of the lease, they ought to contribute. MCL position is that, and BBP wants the landlord to have a unilateral right to go in and carry out those works. MCL position is that the landlord does not have a right to go in and carry out those works. Those are the premises for the tenant to carry out its business operation. If the landlord asks and the tenant consents in its absolute discretion, then the tenant pays. Now, despite thinking that the BBP toolkit is great, my preference really is the MCL position, because occupiers have budgets that they need to manage. So it's unfair to spring them with a huge capital cost, potentially huge capital cost, partway through the term. At least the MCL gives the parties the opportunity to discuss whether the tenant wants these types of improvement works to go ahead, and if it is willing to contribute. MCL says that tenant pays, but obviously because the tenant has absolute discretion to consent, there is the opportunity to negotiate. And it might be that a tenant is willing to contribute, but it doesn't want that premium to be paid in one fell swoop. It might be willing to increase the rent payable under the lease, or it might be willing to agree some other way, some stage payments or something. The other thing I wanted to draw attention to is that in terms of obligation and the need to bear costs, the background statutory regime is MEES and EPC regulations, and they really put all the obligations on the landlord, not on the occupier. It is for the landlord to comply and ensure that it is not letting premises that are substandard for the purpose of MEES. That said, there have been suggestions that when MEES is updated, it will include occupier obligations as well, which could be an obligation to contribute towards the capital costs of works to improve the environmental performance of the building. We just don't know, because they haven't told us what they're considering pushing on to occupiers. And the other thing is that they've said that they might consider this when the minimum standards were supposed to be ratcheted up along a timeline, and that's subject to postponement. The 1954 Act is supposed to be reviewed and possibly updated. I just can't see any of these things happening in the very, very near future.
Thank you very much, Rachel. Right, let's move on to Ruth then. I have a question for Ruth, which is, high street rental auctions sound like a form of compulsory purchase. Would you agree?
I mean, I guess they are in one sense, although it's not a permanent arrangement. You know, we're talking about leases here that be granted for a term of 1 year to 5 years. I mean, hopefully, when they introduce the secondary legislation, we'll see that it'll be a quicker process. And I mean, the parties are going to be on the same page, aren't they? You know, because the landlord owns a property that they want to lease in order to make money from the rental income. I'm not sure about the position on compensation, because obviously under the CPO, the landowner would receive compensation. But I guess the landlord's going to be benefiting from the rental income once it's successfully let under the auction process. But yeah, I mean, interesting question. I've not thought about it that way, but I guess it is.
Yeah, I'd agree. I mean, it's local authorities taking control of it. I suppose the difference is with compulsory purchase, the local authority ends up acquiring an interest. Whereas here, even if And then, as you've said, we're still waiting on the guts of the procedure to be set out in safe legislation. But based on the consultation, the local authority ends up negotiating and signing the lease. They still sign it on behalf of the landlord, and so the local authority never gets. They're not taking interest in the property. They are just sort of renting it out on behalf of the landlord. So it's a great. It's a great question. It has elements of compulsory purchase other than the local authority not actually taking the interest. Right then, let's have a question for Helen then. The first question that came through for Helen was a question: is adverse possession a form of trespass? And if not, what is the difference?
Good question. Adverse possession is where somebody has taken occupation of land to the exclusion of all others and has been there for 12 plus years. So sometimes you see situations with squatters where they take occupation, and if they're left there for 12 years and they're able to demonstrate that they've had exclusive use and possession of that land, then they have dispossessed the owner of that land, and they're entitled to make an application for possessory title. It is a form of trespass, but it's also the extra element to it is that they have to effectively treat the land as if it's theirs to the exclusion of others. So there are things you can do to ensure that they're unable to tick all of those criteria. For example, making sure that you're going onto the land, and if the trespassers are there, there are ways of going on to maintaining the land, cleaning, so on. But really, people need to be very wary about leaving squatters alone in property, because if they're there for long enough, they are entitled to dispossess the owner of the title. So in answer to the question, yes, it is a form of trespass, but there is additional criteria, and obviously a much larger amount of time before they can be considered to have acquired adverse possession.
Thank you very much, Helen. Right, back to Rachel. The second question that came in for Rachel was: is there anything in the RICS service charge code about or that mirrors the aims of the BBP Green Lease Toolkit?
Hi, Bill. Thanks for the question. I know that you're more familiar with the RICS code than me.
Pick that one up.
Yeah.
The short answer is yes. If you look at the RICS service charge code, particularly there's a section 410, social, economic and environmental sustainability, and that includes provisions around green leases, MEES, EPCs, improving environmental performance. And it is consistent with what's in the BBP, talking about the importance of collaboration, cooperation, data sharing, taking, I think, a fair and reasonable approach to carrying out environmental improvements and allocating those costs between the parties. It doesn't go into the same detail in terms of what those clauses should look like, but very interestingly, it hyperlinks to the BBP Green Lease Toolkit. So the two very much dovetailing nicely, and the RICS code referring you to the BBP toolkit to get more detail. So I hope that answers that one. Right, next question then is back to Helen. And a question: if the police won't intervene and the process is going to take 3 or 4 months, where is the law? Where's the law stand as regards fighting fire with fire to remove your trespassers? Great question.
I'm not entirely sure what's meant by fighting fire with fire. I assume it's a sort of, DIY removal strategy that they are referring to there in the question. Where does the law stand? Well, a landowner can use reasonable force if a common law notice has been issued asking the trespassers to leave and they've refused. Reasonable force can be used, but violence cannot be used. So if this involves having to commit some form of GBH or physically picking up people and removing them from the land, that is interesting. That's probably where the police will be very interested, and they will come to intervene if they consider that the peace is not being maintained. Landowners cannot simply, without an order, go in and physically cause harm to individuals. There have obviously been some high-profile cases over the years of farmers taking matters into their own hands, but then it becomes a criminal matter, and the risk for a landowner is that it finds itself in hot water because it's being accused of harming an individual. The best thing to do if people do go in is to, at the moment, is to try and get an order as quickly as possible, and get that order transferred to the High Court for enforcement, because High Court enforcement officers know exactly how much force to use in any situation. They use more force than a county court bailiff could use, for example. They are very, very well trained in using specialist equipment. So if people have climbed up or onto towers or onto roofs and stuff, they are very, very good at removing those individuals. And actually, High Court enforcement officers have very good relationships with the police. And so they work with the police to ensure that they don't cross any lines and that the peace is maintained. So my advice to clients, to landowners, would not be to go in there and inadvertently find yourself on the wrong side of the law because a fight has happened and there's allegations of GBH and assault and all of this sort of stuff. So always seek advice, try and get an order if we think High Court enforcement officers will be used, because they are able to use more force to remove the trespassers. I hope that answers the question. It's a very difficult one, because what's considered reasonable in each situation is different, and each group of trespassers is different, and they know their law. They know the law. They know what landowners can do to them and what they can't do to them. And the police will be very interested if there's a huge fight and it's all kicking off. They will be very interested in that. So obviously that exposes landowners to potential criminal action if they take matters into their own hands.
There'd be ultimate frustration, wouldn't it, that you have this disturbance with your land and you're the one that ends up in court because you've gone beyond what the law permits.
It's a very frustrating, and landowners will feel it's a very unjust situation to be in. They can use reasonable force, but they can't cross the line. And the risk to them if they do cross the line is that they'll face criminal prosecution, which is not what they want to face. But that's why we have a system in place. The most effective way, if trespassers have gone in and they are being very reluctant to leave, the best course of action is to go and get an order as quickly as possible, and to get enforcement agents engaged very, very quickly to get them off. Some I would say here, I didn't mention this in the talk, but actually travellers, because they know this system and they know that if they arrive at a site, usually if they arrive at, say, a retailer car park, for example, maybe the tenant's vacated and there's a car park that's not being used by the public all that often, they'll arrive at the car park and they'll probably say, we're going to be here for 4 to 5 days, because they know the process. They know that at some point they will be told to move, and so generally they work on a system whereby they'll be there for a few days. As soon as they know there's a court hearing date, we've known groups of travellers to just move. They will go because they know what's coming. So not all of them are in the situation where they have to be physically removed. Many of them would prefer not to have to deal with that, and they just move on their own when they know their time is up.
Thank you very much, Helen. I'm going to stick with you because there's a related question. That question was driven by the delays in the process, and therefore can you self-help in the meantime? So the question in terms of what has caused the significant administrative delays with the courts?
Yeah, I mean, I think it's an easy thing for us to say it's COVID and a backlog that's accumulated during that period where, the courts had to switch very quickly from the traditional way to an online way. I mean, I would say that the court system was clunky pre-COVID anyway. Everything was done in-person hearings, in paper, and then we very, very quickly had to shift. They're not particularly well set up for remote working, for example. So I think that period of them effectively being closed has caused a significant backlog. The fact now that they are having to deal with things online has caused issues as well. I think it's a combination of things. There are stark regional differences, actually. So the courts in London and the South East are generally performing worse than the courts in, Yorkshire and the Northwest. I don't know what the reason for that is, but it could be related to the number of cases that they are having to deal with post-COVID. Everything obviously was on hold. For example, possession claims, for example, dealing with tenants, renewals in certain places, those sorts of applications have just been on hold. And the court is slowly adapting to the new way of doing things, hybrid working, everything being done electronically. The frustration we have with them is it's almost daily. We have a few matters on in Wales where things appear to be moving more smoothly. But there's lots of chasing. There's lots of frustration in that the court will tell you to send something by email, and it will also ask you to send in hard copies, or it doesn't actually give you any instructions on what to do until you've sent something in. So it's all very clunky. It needs radical change. It needs radical reform, and I know this is something that's in the legal press quite a lot. So let's see if lessons can be learned and things can be improved. But currently, it's very, very frustrating for not just us but clients who need the court's help. So we do sympathise.
Thank you, Helen. And Peter, who asked the question about fighting fire with fire, he's with a follow-up comment saying, regarding trespassers, we've had a security guard tied up, threatened and the like. Police did nothing to pursue that. Increasingly, occupiers or land owners are frankly left on their own. The police are nowhere in that issue. So, the evidence of the frustrations that landowners are suffering with the current process. Right, Helen, I shall let you off. It's 11:22. One more question, and I'm going to go back to Rachel. It's a lengthy question. Do the green lease provisions acknowledge that reinstatement may be related to an insured risk, and that policy cover may not provide for green reinstatements if they are more expensive, as cover is on an indemnity basis? So do the BBP provisions make the tenant or the landlord responsible for any additional costs incurred?
Short answer to a long question. The BBP provisions don't cover it. They don't address it. In terms of general principles, the BBP is of the view that if the tenant benefits from cost savings as a result of green improvements, then the tenant should contribute towards it. The provisions that the BBP give are to slot into ordinary leases, standard leases, like the MCL precedent that they've used as the basis. Those precedents really put the cost of reinstatement onto the landlord. It is a landlord's cost. Usually the landlord won't have to reinstate to the exact specification that the premises had before they were damaged or destroyed. But if there is a shortfall in the insurance money is received in respect of what the landlord wants to build, then it's normally for the landlord to make up that shortfall out of its own monies, assuming that the shortfall hasn't been created by anything that the tenant has done or failed to do.
Fantastic. Thank you very much, Rachel. Right, so 11:24. I did promise I'd send everyone on their way no later than 11:30, so I'm going to draw a line under that. Thanks again to everyone who raised questions. Apologies to anyone who didn't get round to your question. Thank you to our fantastic panel for your talks and for bravely tackling all those challenging questions that our delegates asked. On behalf of Team HD, I'd like to thank all of our attendees for joining us today. I hope you found it useful, and I hope that we will see you again at future events. So, a final reminder, don't forget to complete the short survey as you leave us. I hope you have a fantastic day. Thank you very much, and goodbye.